Good afternoon, everybody. Welcome back to another employment law Q&A. My name is Chris Justice. I'm an employment lawyer with Samfiru, Tumarkin, as many of you may know. And as always, I'm here today to hopefully answer all questions related to employment. So whether it's something to do with maybe a contract, an issue you're going through at the workplace as I speak, or maybe you've been let go and you've got some questions on your way out, definitely get your questions in today, and I'll do my best as always to answer as many as I can within the time allotted. So before I get into some of those questions, though, I did want to sort of touch base or start off with a few things that are going around in the news. One of the most recent things has to do, of course, with the tariffs that are coming from the US. Those tariffs will apply in many respects across many industries in terms of goods sold and other things and services being provided. And so with the tariffs or the change in terms of the tariffs, that could mean for a lot of people, a lot of businesses, that things may not be as sustainable. Maybe there could be cost-cutting measures put in place in order to deal with these tariffs. And that could result in one or many of you potentially losing your job. And so in the near future, you may very well get a letter from your employer that says, we've got to let you go. It's maybe due to the tariffs, or, there's some financial issues, and unfortunately, we're gonna have to let you go. And then normally what would happen at that point is you would be offered a severance package, say in the event of a reorganization or restructuring. Again, even if it's on the basis or in some way related to the tariffs that are coming up here, that's going to still be justified as a valid reason for letting you go. But it's still considered a without cause termination if that were to happen. And you would be, again, owed your severance. So before you sign off on anything, before you have any major discussions with your employer as far as how much severance is reasonable or whether or not you should take the package, even if you think it looks reasonable on the face of it, you want to give us a shout. You want to get some legal advice, because in the vast majority of cases, anytime someone's let go, regardless of what the scenario is, and they're offered some kind of a severance package, 9 times at least out of 10, that severance package is going to be below, and in a lot of cases, well below what they are or what you're otherwise reasonably entitled to. So again, if you're someone who unfortunately gets hit with a termination or something in relation to something tariff related or anything for that matter, you want to give us a shout so that we can make sure you get your full severance. In terms of what someone's best case severance scenario could be, you're looking at upwards of 2 years, depending on your situation. So especially if you're a long service employee, you're in your 50s or 60s or older, and if you've got a relatively senior or high-paying job, those are some of the main factors that courts are going to be looking at when trying to decide how much severance is appropriate in your case. And so obviously the longer you're there, better paying job or better, seniority in terms of your position, as well as your age, that could all gear towards getting as much, as I say, as 24 months of severance. So definitely give us a shout if you're in that case or in a situation like that. There was another topic that's sort of running the news as well that I wanted to touch on. In this particular case, I was looking at something coming from Dell, the company Dell. They had issued a notice or some sort of sent out some sort of communication to their employees saying that they wanted or they want certain employees or all of their employees to come back into the office to work on site, as opposed to working from home, or as opposed to working maybe in a more hybrid situation where some of your days are working in the office and some of the days are working at home. And this doesn't just apply to Dell. A lot of companies have recently been reaching out to employees who have been working at home and have basically told them that their policy is changing and that they now need to be in the office for a certain number of days per week. And a lot of people give me a call, give our firm a call, and they wonder or not whether a company can force them essentially to go back into working in the office. And it's going to depend on the case. So, for example, if you're somebody who has always worked from home, or you're somebody who maybe even in a contract or in something in writing has something that says you have a work from home position, whether it's 3, 4, 5 days a week, then there's going to be an expectation for you to continue working in that under those terms. Because either, like I say, there's a contract in place, or from the very beginning of your time with them, you've always been working from home. So that's going to create an expectation on your end that the terms of my employment are that it's a remote position. So if that's the scenario or the situation you find yourself in, and your employer is essentially coming to you and saying, well, now we're going to change it, now we want you in the office, you would have a valid argument to say that the terms of your employment are such that it's a remote position. And for you to then demand or insist that I go back into the office and work 3, 4, 5 days a week, that's a significant change to the terms of my employment with you. And it's in those scenarios that you're going to have more leverage to decide essentially whether you want to go back into the workplace or work on site for a number of days in the week, or whether or not you want to sort of treat this almost as if you're being let go. Because there's a phrase that comes up a lot on this show, on other things that we do in terms of the media, as far as the phrase constructive dismissal. A lot of you are familiar with that. That would be when there's a significant change to the terms of your employment that you don't agree with. And if you can establish there's a significant change and it's being unilaterally imposed on you, then those are the scenarios, as I say, where you're going to likely have an option to do what it is the company wants, or try to go after the company or try to get your full severance. But again, before having major communications about your work situation, before having discussions with your employer about, maybe whether you agree to working on site or not, you want to give us a shout, because there are situations where maybe also you haven't been working from home for that long. Maybe it's only been a very temporary thing, and before that, you had always been working in the office. Or maybe your contract says it's supposed to be an office position where you're working a certain number of days in the week, or there's some sort of agreement maybe between your employer and you about working from home versus working in the office. So there could be those situations as well where an employer will have more leverage itself to force that change, or to essentially force you to go back into the office if that's something you had been doing before, or if that's something that's in a contract potentially somewhere. So again, depending on your case, you may or may not have leverage to, seek your full severance versus having to accept what the company's asking and going into the office. But definitely give us a call before that, as I say, before having any communications with your company, because if there is a constructive dismissal, if there is that situation in your case, then you would potentially be entitled to the same amount of severance as if you'd been let go. I started off the show by talking about people who may lose their job due to the tariffs that are being imposed in the country. And those people are owed severance. And the same thing could very well be in a case where a company makes a bunch of changes or a significant change to your employment and tries to force you into accepting that change. So those are sort of two of the topics that have run the rounds in terms of the news that I wanted to bring up with. I've got a little bit more I can talk about in terms of some general topics, but I do want to get into some of the questions. And if I have time, I can go back to that. So the first question is from Gizzy on YouTube, who's saying, I have an open human rights complaint regarding a situation about disclosing personal information and discrimination based on Indigenous identity. Are you lawyers able to help me? The short answer to that is yes, we are generally able to help in terms of human rights cases. That can also potentially include human rights cases that have already been started. So maybe you have opened your own human rights complaint, but perhaps need some assistance in completing the next step, or maybe there's a mediation scheduled and you want some legal counsel or some legal presence there. We can definitely look at your case. As I say, we do human rights stuff all the time, whether it's through the Human Rights Tribunal itself, or sometimes we'll start a lawsuit, a legal action, and in doing so also include a human rights component. So certainly if you're in that sort of situation, give us a shout. and we can at least set up a time to speak with you just to get a sense of exactly what your human rights case is about, what the next steps are, what, if any, legal fees will be applied on a sort of a go-forward basis, or how the legal fees will work in general. So give us a shout. It's definitely something we can help out with, but thanks for your question. Moving on, I've got another one from Amanda on Facebook, who is saying that their boss is forcing them to start working at a different location that's going to take 2 hours of a drive to get there. And then the question is asked whether or not they can move this person to a new location like this. Is there anything I can do? I'm thinking about asking to be laid off. So I would, again, hold off from asking to be laid off. Again, you don't want to have any major communications when it comes to you and the company around changes to the terms of your employment. I mentioned a minute ago the idea of a constructive dismissal and how that could potentially apply where a company demands that someone go back into the office when maybe they've been working from home for a period of time. In Amanda's case, it's similar logic, similar rationale. The difference, though, being that the change has to do with moving to a different location altogether. And that can certainly be a big enough change to trigger a constructive dismissal. So, for instance, let's say you work at a particular location 5 days a week, and it only takes you 15, 30 minutes to get there one way. But now the company comes to you and says, we're moving locations. Now it's going to be 2 hours. Well, that's adding an hour or an hour and a half or more onto your commute just one way. And I think in situations where I would say at least an hour, if not more, is being added to your commute time, that's going to normally be considered a significant change on the issue of location. And so that could also entitle you to push back and to basically say, look, I've been working at this one location for X number of years. It's only taken me this amount of time to get there. You're now telling me to move to this location. It's going to take this long to get there. And if there's a big enough time difference in terms of your commute, as I say, you may have the option to consider that almost like a termination as well, and go after your full severance if you chose not to go to that new location. But again, you want to give us a shout so we get the full particulars. We understand what the difference is between the first location and the second. And then if there is a viable constructive dismissal claim there, we would either suggest, depending on your case, you or us jump in and communicate something to that effect to the company. Again, especially if you don't have any interest or zero interest at all in working at that new location, it wouldn't make sense for you to otherwise just walk away and get nothing when you could be leaving a lot of money on the table as far as a potential severance payout. So getting laid off, that could be a potential avenue, but before asking them and maybe tipping your hand to them in that sense, you give us a shout and we can kind of take you through the full thing and make sure that you at least know your options and what sort of each option will allow you to achieve or allow you to get. I've got another question in from Jedi on YouTube, who's saying that they just got an email from their supervisor saying that they're being investigated for a serious concern and they're not allowed to talk to coworkers while they investigate. What should I do? Again, I would say give us a shout. It sounds like there's at least some serious accusation or allegation. A lot of times when there's an investigation done, it depends on what the reason for the investigation is, what the allegations are. But it can very easily be pretty normal and accepted for employers to have the employee who's a subject of the investigation not talk to other coworkers. It wouldn't apply in the general sense, but perhaps the idea is that there are multiple people involved in the investigation and the company is trying to just eliminate the possibility that there's any sort of tampering or pressure or communication to any significant extent between those getting investigated. They want to make sure that they do and complete a full, fair, non-biased investigation. And a lot of times that's why there is a sort of statement about not talking to other coworkers while they investigate. Sometimes as well, when you're investigated, you're put on an unpaid leave of absence, or in some cases a paid leave of absence. Depending on the case, that can be either problematic or not. It's not in all cases that companies can just simply put you on some sort of administrative suspension or or disciplinary suspension. It kind of comes down again to what the allegations are or what the context of the case is. I, at the moment, probably wouldn't be talking to any coworkers, just because you don't want to give the company any further leg to stand on or any excuse to kind of maybe go down the path that they intend on going down or looking to go down. But given what looks like a serious sort of situation that you're in, and probably a time sensitive one, I'd suggest giving us a shout so we can get a bit better of an explanation in terms of what's going on. And then from there, maybe advise you how to best communicate to your employer. And also just to give you a sense of what is normally acceptable in these situations, and in situations where employers also go too far, which could also give you a bit more leverage or leg to stand on. But thanks for your question, Jedi. We've got another one in from Gloria, who's asking or saying that they need to talk to a lawyer about defamation. Definitely give us a shout. We deal with defamation as well. So if you can make out, of course, that you've been defamed, whether it's in writing or verbally, by showing that, I guess, in general, what is being said is untrue. And secondly, what's being said is having an effect on your reputation or your livelihood, your ability to earn a living, perhaps, or in other words, is just having an effect on your ability to make money, or at least causing damage in some way. So if that's sort of the scenario you're in, definitely give us a shout. Now, defamation can be difficult to prove. A lot of times it does come down to a he said, she said, which can complicate things a bit. But there's also cases where, as I say, it's in writing, or where there's otherwise some pretty compelling evidence that defamation has occurred. So if there is defamation, for sure, give us a shout. And in these cases as well, a lot of times the longer this defamation goes on for, the more damages that can be caused. So this is also a pretty time sensitive matter in general. So all the more need to give us a shout, and we can at least go through your situation, see what help we can be. I've got another question in from Mendel, who's saying, if your employer announces retirement and business closure, are you owed any severance? The short answer to that is yes. A lot of times people work for a company says we're closing up shop. I'm retiring, whatever. I'm not continuing on the business. We're going to be closing on this day. And then they think that because maybe it's in the context of a closure of a retirement, that somehow there may be different rules applied in terms of the severance, that, maybe someone doesn't get as much severance as compared to a company that's not closing down, but just decides to let somebody go. But in general, both situations are treated the exact same. There are rare situations where a business will close specifically due to serious financial issues, and the business will actually go further and file for bankruptcy. In those cases, sometimes it can be a bit more challenging or tricky to get money out of them if there's no money to be had, but that's still a relatively rare occurrence. So I wouldn't assume that unless there's some evidence to suggest that much. So Mendel, give us a shout, because I was mentioning at the top of the show, depending on who you are, and again, even in a business closure situation, you could get upwards of 2 years of severance. But thank you for your question. I've got another one in. I've got a follow-up from Gizzy on YouTube, who's saying they. And just to reference back the question, so it was. Sorry, Gizzy, 1 second. Just regarding a human rights complaint. Are we able to help in terms of an ongoing human rights complaint? I had made my statement that yes, we are. Gizzy's responded just to say, I've paid you already. Would I have to pay again? So it would just depend, Gizzy, on what the, I guess, retainer was initially. So if you maybe used our firm's services for a time limited basis, then you may have to pay again, or some other legal fee retainer may have to be created if you want us to continue working ongoing. So it just depends if, like I say, your first retainer with us was for just a limited basis, or if it was indefinite. If it's indefinite, then I would imagine the same terms apply. If the retainer you got initially is over, or it was just to be a one-time thing, and you want us to take more active involvement going forward, then in likelihood there would have to be a new retainer signed. But that's something in terms of the legal fees themselves that you can connect with us on, and we can at least give you a sense of what all your options are as far as legal fees are concerned moving forward. Got another question in from Reg on YouTube, who's saying that they're working for a US-based company as a remote agent in Canada, are they subject to American laws for their employment? And so in general, no. If you work for a US company, but you've always been based, let's say, out of Toronto, Ontario, then in most cases, the employment laws that apply to your case will be the laws that pertain to the province you live in. A lot of people may think that because the company's American, somehow, if I'm let go, maybe it's the American laws that apply. Like I say, that's generally not the case. So it would depend on, I guess, where in Canada you're working. But for the most part, someone's severance entitlements, as long as they're working within Canada, are still going to be that upwards of that 2-year severance entitlement I was mentioning. Again, regardless of whether or not the company they actually work for is American or European, the focus primarily tends to be around where that person's based out of. I've got another question in from OCB on Reddit, who's saying or asking whether can my employer refuse my accommodation request and force me to apply for disability? I requested accommodations for after hours on-call work that my doctor has said I can no longer do. Is this allowed? So there could be an issue there for sure in terms of your employer not doing something that it should be doing. There is a general obligation on employers to accommodate disabilities to a certain point. Of course, there's always a threshold that they would reach before they can say, this is too much. And for the most part, that threshold is very high. So it's very rare that an employer can say, we don't want to accommodate you because of this, this, or this. They would have to really show that the accommodation would drastically alter the nature of your job or would, create a lot of damage or loss for them financially, especially if they're a very large employer. So it's not as easy as just saying, well, we don't really want to accommodate you because it's a bit of an inconvenience. Even if it is an inconvenience, again, as long as it's not dramatically altering your job, there is a general expectation that they accommodate. And if they don't accommodate and they refuse to accommodate and try to force you into some disability path, they could very easily be seen as failing their obligations to you in that regard. And that could be seen as a human rights issue, which could allow you to go after the company for full severance and potentially human rights damages. So it may come down to how big of an accommodation it is. But it seems like you have the support from your doctor as well. And unfortunately, a lot of employers just think that they don't have to do as much as they do have to do. So I would say give us a call, because these situations can also come down to exactly what maybe the medical note says, what the accommodation is, again, how dramatically it changes the nature of your job. But if it's a relatively minor extent, then there should be some more effort to accommodate rather than to just push you down the disability path. So give us a shout, OCB, but thanks as well for your question. Reg, just following up on his earlier question, saying that he's working for a U.S. employer but based in Canada, saying that they're at-will workers. They don't get severance if they get let go. So that's a U.S. termination sort of situation where there's at-will termination. You can be let go and get a lot less than you would be if you were in Canada. But again, it's where you're based out of. So I don't know what their legal argument is exactly in support of what they're saying, but maybe all the more reason to give us a shout, and we can get to the bottom of it either way. I've got a question in from Bumblebee on Reddit, who's saying that they're being let go from a contract position because they're not suited to the job.